Welcome to the JMW Inside Man YouTube channel from JMW Solicitors. Please subscribe to the channel for the latest legal news, insights and tips. Please like the video and also keep the conversation going in the comments section as well. Now, we're told that temperatures may reach 37 degrees Celsius in the heat wave that's coming up. Simon Block is a partner within JMW's Employment Law Department. So Simon, can employees simply say, look, it's too hot, I'm not coming to work?
So the simple answer is no, Dominic. They're not allowed to say that they're just not coming into work. Employees are bound under a contract of employment to perform a function and a duty as required by the contract. And therefore, they can't just say they're not coming into work. There are specific statutory protections in relation to health and safety. And in fact, there has been a recent case which has considered the question of an employee who was dismissed for leaving work and refusing to return to work because of COVID-related concerns.
So you mentioned the case about COVID. What actually happened in that case, Simon?
The case related to an employee who was dismissed for leaving work and refusing to return because of concerns about COVID. And he brought a claim under the Employment Rights Act that he was automatically unfairly dismissed for health and safety concerns.
What did the court decide then?
So Mr. Rogers' claim was dismissed by the Employment Tribunal. He appealed, but the claim was also dismissed by the Employment Appeal Tribunal. And what the EAT had to go on and consider was the question, and I'm afraid it's a technical question, Dominic, whether that leaving or refusing to return to a place of work could fall within the provisions of Section 100D of the Employment Rights Act and could not constitute the question of taking an appropriate step under Section 100E. So the appeal only went on to consider the case under Section 100D, which was the leaving or refusing to return to a workplace, and whether he was dismissed as a result of that.
So with the imminent heat wave, Simon, why is that particular case important, and how can you and the team at JMW Solicitors help employers?
So this case is really important in the context of what's happened with COVID, because we've been faced with situations where employers have felt very unsafe at work. So it's an important decision to be aware of from COVID, but it does give other messages in terms of health and safety risk at work. And as you've identified, in light of the fact that we're about to be hit with serious scorching temperatures that this country has not seen for many, many years. So I think a few points to take away from this case are as follows. The protections under Section 100 of the Employment Rights Act in relation to health and safety can apply to dangers at large. So in the context of COVID, generally what was happening within the world at that present time and the dangers that were presented by it. So it doesn't have to specifically relate to a danger at work, but it's not going to be enough that the employee has genuine concerns about either the pandemic or the health and safety risk that is presented or their family's health. The employee is going to have a reasonable belief, and that's the key point here, about the serious and imminent danger that affects their ability to go to work. And I think the point is that it's going to be quite hard to establish a reasonable belief in a serious and imminent danger if the employer has followed all of the government's guidance on public health and safety advice, whether that be COVID or in relation to working in high temperatures, and the employee doesn't raise any specific concerns about how it affects them in the workplace. The other point that I think is useful and relevant to take into account, especially where employees are saying, I can't come to work for this particular reason, is that the extent of the employee's risk avoidance outside of the workplace could be a relevant factor to take into account in showing whether they hold a reasonable belief that coming to work presented a serious and imminent danger. So I think in terms of how employers can react to this, whether that's in light of COVID or other health and safety issues that may arise, is having proper guidance and processes in place in relation to health and safety risks, be that COVID or be that in relation to working at high temperatures. That's going to go a long way to helping you establish a good defence or case if an employee is to challenge this and say, I am not coming to work, and the reaction is to subject them to a dismissal or to a less favourable treatment.
Simon, thank you very much for your insight. And if you'd like to speak to Simon and the employment law team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, insight and tips as well. I'm Dominic Walker, JMW's Inside Man.